Good afternoon, everyone. I'll call this meeting of the Building Standards Appeals Board to order now. Would you please call the roll, Secretary?
Board Member Field.
Here.
Board Member Mears.
Here.
Board Member Ransom. Here. Vice Chair Vincent. Here. Chair Golick.
Here. Okay, we will first have a staff presentation and then followed by the presentation. The project applicant will present testimonies from supporters of the project will be taken, followed by testimony for the opposition. The applicant will have the right for a final rebuttal and prior to closing the public hearing. So is that all clear to everyone? Okay, in accordance to the standards, we have a length. The public testimony for those in support and opposite will be limited to 3 minutes. Just remember that. There is a light that will turn on next to the microphone, and it will indicate the amount of time that's remaining. So you kind of will give a warning. So let's see, where am I? No. The speak begins. The yellow light will come on, and a soft bell will ring. That means that you have 1 minute remaining. And then it'll be followed by a red light where it says, that's it, you're done. The public testimony must be presented to the board in the podium. So there is a podium there that you will have come in. Any testimony that references race, religious, ethnicity, economic status, national origin, or any other classifications protected under the state and federal law and in a derogatory manner and shall be deemed irrelevant and will not be considered by the board. If you challenge these land use matters in court, you may be limited to raising only those issues that you or someone else has raised in an oral presentation or testimony before this hearing. Now we'll proceed with the approval of the agenda. Let's see. Are there any changes to the agenda?
Good afternoon, Chair and Board. Ashley Atkinson, Assistant Director for Planning and Development. There are no changes to the agenda, but if I could just ask everyone to be sure to move the microphone close enough to you that you can be heard by the audience, that would be appreciated.
You can't hear me? Oh.
Now we can, yes. We could not hear you before.
I can hear me too. Oh. Are there any proposed changes? What is going on?
You're on now.
Okay, but why am I buzzing?
But it's off, so it won't record. There.
Are there any proposed changes to the agenda? No. Is there a motion to approve the agenda?
So moved.
Okay. Is there a second? You got a second? Okay. All in favor, say aye.
Aye.
Opposed? Then we will move to onto the consent calendar.
Madam Chair, is there a hard copy of the agenda that I could have? I didn't get one. I've seen it, I've read it. Thank you.
I will give you a moment to look at this. There are no items on the consent calendar. Items in the consent. We will now move on to the board members' report. Any board member that wishes to make a report? No reports from anyone.
Sorry, we do need you to use the microphone, otherwise
You can't hear me.
It needs to be closer to you.
We will get this together soon.
You can pull it.
Oh, I think I should do that You're right.
There you go.
Okay, so we do not have any board members that wish to make a report. So let's move on to the public comment. That's what you all want to be. We're going to take a public comments now on all matters. Would any member of the public like to speak on items continued or new matters? Anybody? Okay. So we will move on to continued matters. Actions pertaining to Fresno Code Enforcement Case Number E25-06722 concerning 7462 East Fedora Avenue and the administrative citation issued on November 3rd, 2025. The hearing will be held as follows. So we have a staff presentation first.
Yes.
Okay.
All right. All right. Good afternoon, Board. Christina Roberson, Assistant City Attorney on behalf of Code Enforcement. We are here today again because an appeal was requested by property owner Angelica Sanchez and or possibly tenant Carmen Sanchez regarding the property listed 7462 East Fedora. The presentation again will be by myself, Christina Roberson. We also have the inspector who was assigned to the case, Gilbert Ruelas, in the audience, Community Revitalization Specialist. After today's hearing, the board may take one of the following actions. The board may deny the appeal and confirm the administrative citation that was issued on November 3rd, or the board may grant the appeal and dismiss the administrative citation. Code Enforcement staff recommends that the board deny the appeal and confirm the administrative citation for the reasons I will discuss. Briefly, a Code Enforcement case summary. On May 21st, 2025, the case was opened based on an anonymous constituent complaint. The substance of the complaint is listed on the screen and in the presentation in the packet. It was construction without permits, large garage in backyard. There were initial inspections, the last of which was on May 30th, 2025, and multiple violations were confirmed, which is reflected on the appeal packet, page 26. A notice and order was issued on June 10th, 2025, with a deadline of June 28th. This included a violation for an illegal structure. You can see here reproduced in the presentation the front page of the, let me see if I get this. The front page of the notice and order, as well as the violation that is at issue in this proceeding. There was a reinspection on October 30th, and violation 3 for the large accessory structure remained. You can see in the photo, it is in the rear of the photo, the second roof line. That is the accessory structure that we're discussing. On that same date, October 30th, 2025, a $250 citation was issued for that violation. The appellant did take some actions in this case to attempt to comply with the notice and order. Just as a side matter, this was violation number 3. There were 2 other violations that were cured, as well as that the appellant applied for a permit through the Building and Safety Division for the accessory structure on June 16th. 2 emails were subsequently sent to the appellant requesting additional information. They're both reproduced in the appeal packet, pages 48 and 50, and the substance of the email is also reproduced in the presentation. In order to deny the appeal and confirm the citation, the board must be satisfied beyond the preponderance of the evidence that a violation of the FMC existed on the property, proper notice was served on the property owner, and that after the deadline passed, the violation remained. Preponderance of the evidence, just as a side note, is basically more than 50%. Just over 50% is preponderance of the evidence, and that is the standard called for in the municipal code. For the first factor that I just laid out, a violation of the FMC did exist at the property. FMC Section 11-103 basically states that our municipal code adopts the California Residential Code. The California Residential Code states that a person who intends to construct a building shall first make an application to the building official and obtain the required permit. Those sections are reproduced in the appeal packet, pages 60 and 61. As of May 30th, 2025, no permits had been applied for with the Building and Safety Division. That was when the notice and order was issued. Appellant does not argue that the structure does not require a permit, and the appellant's appeal form requests that additional time to comply with the correction notice, but does not state that the accessory structure is not in violation. That accessory structure, again, was large enough to require a permit, and the appellant did subsequently apply for the permit, but when asked for additional information from Building and Safety, she has not provided that information, and therefore the permit has not been issued. The second factor is that proper notice was served on the property owner. On June 10th, 2025, the notice and order was posted on the property and mailed by both first class and certified mail. Proof of those items is reflected in the appeal packet, pages 27 to 29. The notice and order contained all the necessary information required by the municipal code section related to notice and orders, which is also reflected in, or reproduced in the appeal packet, and the appellant did not appeal the notice and order. After the deadline passed, the violation remained. The deadline was June 28th, 2025. The violation was confirmed at multiple re-inspections, including October 30th, immediately prior to issuance of the citation. The inspector attempted multiple times to communicate with the appellant, and he did provide extensions when she showed progress by removing other violations and also by applying for the permit. However, after 4 months of extensions, the citation was issued because the violation still remained and the permit had not been obtained. On November 3rd, 2025, this first citation was mailed by both first class and certified mail, which is as required by the municipal code. It also contained all the necessary information pursuant to FMC Section 1-308B. Again, staff recommends that the Building Standards Appeals Board deny the appellant's appeal and confirm the administrative citation that was issued on October 30th. And I'm here for any questions, as well as the inspector, who is also here.
Thank you.
Thank you.
Do we have a presentation from the applicant? Step up.
Hi, I'm Carmen Sanchez. I lost my home and I had to find a place to put all my belongings, so I had my daughter build me a shed in the back. It was just the empty building, nothing in it, and I didn't think anything was needed to build that, since nothing was going to go in it except my belongings in there. So then I hear that I needed a permit and all that. I need more time to take care of it. I have to hire people to come and bring it down and apply to redo it at the size that was needed there. So that's my, what never been here, never done this, so, bear with me. But I do plan to do something about it and get some help in bringing the structure down. But I need time. I need more time. That's my issue right now. I don't have the means right now to hire somebody and come and bring everything down, take everything that's in there out. So that's my issue.
Okay.
Thank you.
Do we have someone in support?
Well,
I'm
do you-
sorry.
Oh,
We're going to have
sorry.
discussion.
Correct. It's aluminum, I guess you say that.
There you go. Sorry. So I did hear you say it's a prefabricated structure.
Correct.
Good, thank you.
And when you purchased it, did they say anything that you needed to have a permit?
No, no. So I didn't know.
And who built it for you?
Who did it?
Yes.
The company that I bought the material, they had somebody, send somebody to do it,
Okay.
to build it, put it together.
Do you have a size for this structure that you put up there? Do
Do
you
I
know
have a
how big is it?
I don't have, no, I don't have that right now.
So just for clarification, if I can, you're saying that this is a prefabricated building? Or did they come and assemble it and,
They came and assembled it,
okay.
yeah.
So they built it from the ground up. Did they pour concrete? Does it have a concrete foundation?
Concrete was already there when they got there.
Okay. So they built a building on the existing concrete.
Correct.
It looks to me like it might be the size of a two-car garage. Is that fair?
Maybe one,
One.
yeah.
Okay.
I don't believe it's a two-car garage.
Okay. But you hired a company to build it.
Well, the company that I bought yeah. They the ones that send somebody out to do it.
May we ask who the company was?
They asked,
Who was the company that you hired?
okay, I don't have that information with me, sorry. My first time, I didn't think I needed all this. I do have all that, but I don't have it with me.
So you have applied for a permit and you're in permit process. What is keeping you from finishing getting your permit?
I didn't, for one, they were letting me know that it was too big. And we were having questions on because it was too close to the house. And our question was, if we take the patio out, will it be sufficient for us to keep the building there so that I can keep my stuff there? But I never got an answer on that one.
So just the one item as far as where it's placed on the property is the only thing keeping you from getting a permit?
What's keeping me from getting a permit?
Right.
I think I can get I didn't know that, we were going through the issues. I didn't know that I could apply. I never done this before.
I understand. Well, you're in the process.
Yeah,
They've
but
asked
if I
you-
can apply for it, I will certainly try and apply for it and
Well,
see.
you have applied for it by submitting your plans to the city. That's an application for a permit.
Okay,
They're giving you a plan check now. They come back and said it's in the wrong place, and that has to do with distance between existing structures and fire requirements and all that kind of thing is why they're giving you that. It is in the code. Are you able to relocate the building as they've indicated or not?
relocated?
Relocate it on the site, but move it so it's not so close to the home.
You know what? I'm not sure about that because on the sides, we were okay with it.
Okay?
So there's no more room to push it back if we're okay with the sides.
Okay? All right, thank you.
Well, I have a couple more questions, and you may not be able to answer them. What I understand is though you've not filed for a permit for that building at this point, right?
Well, could
You've
you-
not filed with the city of Fresno for a permit to construct that building?
I did not file? No.
Yes, okay, that's
No,
what I understood.
is that what you're saying? I didn't know that I needed one since it was just a
Sure. Right,
building with nothing in it, empty one at
yes.
the time.
Well, I'm sorry that you're going through the things you've gone through. I understand this can be confusing. And frankly, I think you're a victim of some really poor advice your contractor should have been right there on top. He should have told you you needed a permit. I need to ask the staff a question, though. Is the only remedy to this situation for her to tear that building down? Because it seems to me that that's what she's trying to do.
Tear the building down?
This is a question for staff who's behind you right now.
Yeah, would
Oh,
you,
I'm sorry.
Let me just come in really quick. Thank you. I think that the remedies, and let me go back just briefly to your previous question. There was a permit applied for on June 16th, and then the Building and Safety Department has requested additional information, which again, on the appeal packet, page 48, they've requested, please provide plans for your proposed shed, a site plan, foundation plan, roof framing plan, structural, et cetera. So they've asked her for additional information, and it's my understanding that has not been provided. Regarding your question about the remedies, I think that she would either need to follow through with this permit, whatever the plan check requirements would be, or yes, remove it. But the actual notice and order states that she can apply for the permit or remove the violation.
So am I to understand that the permit was never applied for?
She has applied for the permit. She's
Well-
not received the permit.
For clarification, the building department will not accept an application without, if they're saying that you need plans,
Right.
you haven't actually filed the application.
Right. She's
It hasn't gotten to the point that they've reviewed it for completeness and said, here are the fees that are due, pay the fees and we will process the plan check.
Right.
So she may have, we're splitting hairs here, but she has not formally applied. She may have shown up at the counter and tried to ask for a permit.
Right.
Which
There
is what I
just a
think.
yeah, there's an initial record.
Yeah.
And that's as far as it's gone,
That-
as far
that's
as
what
we
I
can
want.
tell.
Okay, thank you.
Thank you.
thank you for that. Any more questions for the plaintiff?
Sorry, are you done with me?
The other question I have is for the contractor. Have you contacted the contractor to get plans to help work through the permit process?
I'm sorry, I'm not understanding.
The contractor who built the building,
Correct.
they had to have plans to build the building for the most part. Since it was a pre-designed building, they designed, or they built it per that design. Therefore, they should have plans that they can give you that will help you submit those plans to the building department.
Okay.
Have you contacted them about plans for this building?
You know, my daughter was helping me with this. She might have contacted the company for those plans and asked if we needed plans. I'm sorry.
Okay. Because that
But we
would
didn't
be-
we didn't get any plans, no.
Okay.
Because in order for you to ask for more time, you have to give us some sort of an evidence of what you're trying to do. And just asking for more time doesn't, it doesn't work this way. You need to have plans and you need to have them present so that our department can check them for you and make sure they're safe.
Okay,
And kind of have a timeline, not just to ask for more time, but tell us how much time you need.
till June?
Till June?
Uh-huh.
So another 4 months or 5 months?
What if we kind of stage this thing? Because I understand it's going to take a month to plan check, to get through the plan check process,
Right.
okay? Do we say that there has to be an accepted application in a certain time frame and not just open it till June?
Yeah, that's what I'm thinking.
Because at that point, it's not just letting it drift till June, it is,
Applied.
we're setting it. I'll be honest, I've run into unscrupulous contractors like this. My parents had a RV they wanted to cover, And the contract, the person that sold him the cover told him, as long as you don't bolt it down, you don't need a permit.
I've heard that one.
No, that doesn't work. So I know there are unscrupulous people out there like that. So what does the board feel is a reasonable amount of time to get plans prepared and submitted?
One more question, if I may. Is there any electrical run to this building? You have
No.
lights?
No.
No light. Okay, thank
Nothing.
you.
So it's just the building.
That's it.
I'd feel okay going with a plan acceptable to the building department submitted by June.
Me too.
Whether she does it via her contractor, however she does it, hires an architect, something has to be in and accepted by the department by June.
Yeah, I agree with Rick's plan.
So do I. Just get yourself your contractor or somebody that can draw drawings and show us, and do it by June or before that.
Okay. Okay.
What's your staff's opinion?
Thank you.
Thank you. And code enforcement is willing to work with appellant on the deadlines. That's fine. We can discuss the timeline that is proposed by the board. For the purposes of today's hearing, though, again, we would request a decision on the citation that is at issue today. Again, staff is recommending that the citation be confirmed.
But it's based principally on fact and on code. I think we don't have any choice but to affirm.
Agreed.
You just restate that for me? I couldn't hear.
I'm saying that the citation that's been issued is based on code and what's actually happening there, so I think we only have the choice, really reasonable choice, is to affirm the position of staff.
Well,
And if we do that, what does that mean to the plaintiff?
Well, we'll have to ask the attorneys about that, but my intention was we affirm that there's a violation. It hasn't been acted on. That's all well documented now.
Right.
We allow from that point now on till June to have submitted to recognizing that there is a violation. Staff is correct. The report that they made is correct and acceptable. I'm just suggesting that we allow her till June in good faith to get a hold of this contractor and try and make this thing done.
So I need to hear from staff, if we do that, what is the consequences?
I think our request would be to confirm the citation, and then we would, if it is the board's decision, not issue a subsequent citation until after whatever the deadline has passed. We could allow her additional time as long as, again, we're requesting that this citation already issued be confirmed.
Thank you, staff. I appreciate your willingness to do that and work with the plaintiff. I'm good then.
So that they can.
Yeah.
We need to make sure that we have to follow this. The public testimony, do we have anybody that would support this testimony? Nobody? Okay. So, all right, so now we need to take action. So let's take a vote, and all in favor?
Well, no, we have to get motions and seconds.
Okay, do get your motion.
Okay, I'd move that we would affirm the citation with the caveat attached to it that code enforcement give an allowance to June to work with the appellant to get plans filed with the City of Fresno Building Department and accepted before any further citations be issued.
Do I have
The suggested amendment, do we have a
Excuse me.
date in June?
Yeah, let's get a date.
1st of June? 30th of June?
Today's the 3rd.
the 3rd of June?
3rd.
Okay.
I'll second it.
You second it, all in favor?
Aye.
Aye. Opposed? Okay, the motion is carried. Thank you.
Thank you.
Thank you for coming in today.
Thank you.
Okay, let's go to new matters. So we want approval of the amendment to the City of Fresno Building Standard Board Rules. Is there, we have an amendment, is there a motion to approve the amended City of Buildings? Okay, approval.
Need a presentation on it.
Oh, do the presentation.
Good afternoon again, Chair and Commissioners. Just a very brief presentation on this topic. Last meeting, we had brought the Building Standards Appeals Board rules and regulations to you for approval, and those who were here at the last meeting requested an amendment be made in order to have some attendance requirements for board members and consequences if those requirements were not met. So we don't have a written staff report, but if you refer to page 8 of the rules and regulations, there is a new Article 4, Section 3, attendance by the board members, which reads, no member of the board will be absent from 5 regular board meetings during a single fiscal year. Should a board member accrue 5 unexcused absences, the secretary of the board will notify that board member and the office of the mayor in writing and may result in removal from the board. An excused absence from a board meeting may be obtained by providing notice of the proposed absence verbally or in writing to either the chairperson or the secretary. So that's our proposed language. We do not have authority to appoint or remove members from this board. That is with the office of the mayor, so it's at their discretion. But that is our proposal for the regulation for you all to try to follow.
Do we need discussion over it?
Just letting other people that weren't here.
Yeah.
Part of it was my experience on the Historic Preservation Commission. And we had a commissioner that just decided he was going to slow things down by not showing up, which put a burden on all the other commissioners. The language is exactly what we had put into the bylaws for the HPC, so I think it's very appropriate. It worked well. 10 years on the commission, we had one person that this was applied to. So I don't see it being a big thing, but it's just making sure we, have something there in case the need arises.
Yes, and this was modeled on the language from the HPC, although you do have, in theory, twice the number of meetings potentially since they only meet once a month. So was
we
adjusted.
met once a month. This is twice a month.
Yeah.
So.
Are there any discussions or any thoughts about this?
I read it. I thought it was very well done, and I appreciate staff for doing it. Thank you.
Yep. Well done.
Thank you.
Okay, well, do we?
Move
need
to adopt the amendment to the bylaws.
Any seconds?
Second?
Second? All in favor?
Aye.
Okay, then this is approved. Let's go on to the next one then. Okay, action 8B pertaining Fresno Code Enforcement case E25-16428 concerning 7443 North Van Ness, and the notice and order issued on December the 4th, and the hearing will be held. So do we have a presentation? Staff?
Yes. All right, thank you again. Christina Roberson, Assistant City Attorney on behalf of Code Enforcement. Here in this proceeding, we're here regarding the property at 7443 North Van Ness Boulevard. This is an appeal of a notice and order, different than the last one that was an appeal of a citation. At today's hearing, the board may take one of the following actions: deny the appeal and confirm the notice and order issued December 4th, 2025, deny the appeal in part, grant the appeal in part, and confirm certain violations and dismiss other violations, or grant the appeal and dismiss the notice and order issued December 4th, 2025. Code Enforcement recommends that the board deny the appeal and confirm the notice and order in option 1 above. Briefly, a code enforcement case summary. The case was opened on November 24th, 2025, based on a constituent complaint. That the substance of the complaint is reproduced in the presentation and in the appeal packet. Rubbish, junk, miscellaneous items, vehicle repair, and it also said this activity has been ongoing for years with no end in sight. There were initial inspections, most recently on December 3rd, 2025, when the violations were confirmed. On December 4th, 2025, the notice and order was issued for 5 violations. The first was that the house is being remodeled without the required plans, permits, and inspections. The second was for rubbish and/or junk. The third was for outdoor storage of household materials. The fourth was for a vehicle on an unimproved surface or unpaved surface, and the fifth was for exterior stucco added without the required plans, permits, and inspections. Staff analysis: in order to deny the appeal and confirm the notice and order, the board must be satisfied beyond the preponderance of the evidence that the violations of the municipal code existed on the property and that proper notice was served on the property owner. Regarding violation 1, which was for construction activities without permits, similarly to the last case, FMC section 11-103 states that the municipal code adopts the California residential code. The residential code section 105.1 requires that a person who intends to construct a building and do other repairs to a building shall first make application to the building official and obtain the required permit. That full section is reproduced in the appeal packet, page 42 and 50. Senior CRS Nunez, who again is here in the audience today, Carlos Nunez, observed evidence at the property during his December 3rd inspection that showed evidence of plumbing removal, including a sink, toilets, and some type of large plumbing fixture. The removal and or replacement of each of these items would require a plumbing permit, and no building permits have been sought for this property. Here are some of the photos that were taken on December 3rd. It is a little hard to see, but you can tell that in that photo, which has just been blown up so you can see better, there's at least 1 or 2 toilets present. There's a sink laying on its side, and then on the far right side of the photo, there is some type of a large plumbing fixture. It appears to be some type of jacuzzi tub, but it's a little hard to tell from that photo. I don't know if this has okay, never mind. I won't point then. But yeah, so these photos are in the appeal packet, page 23. Additionally, just as an interesting additional item, in that same photo that I showed you on the last slide from December 3rd, there's something in the background that you can't quite tell what it is, but when another photo was taken at a reinspection on December 23rd, which is reproduced there, and you can tell now that that is an additional toilet. So there were at least 2 to 3 toilets, that sink, and that large plumbing fixture present at the property on December 3rd. The second violation was that there was junk and rubbish present at the property. Fresno Municipal Code section 10-605 makes it a public nuisance to maintain a variety of rubbish on the property. During his inspection, Senior CRS Nunez found the discarded plumbing fixtures, pieces of lumber, and other items that constitute junk rubbish and a public nuisance visible from the exterior of the property. Some examples are reproduced here. Looks like possibly some construction materials, pieces of lumber, and other items in front of the property. Violation number 3 was that there was outdoor storage of household materials. Municipal Code section 10-605 makes a violation of a zoning ordinance a public nuisance. FMC section 15-2013B prohibits the outdoor storage of materials generally found in households in a residential area. Those sections are reproduced in the appeal packet on page 48. During the inspection, Senior CRS Nunez found building materials, plastic tote containers, and other materials generally found in households visible from the exterior of the property. Some examples, again, are some of these fixtures. There are some tools present, some pallets, and other materials, again, that would be considered household materials. Violation number 4 was that a vehicle was parked on an unpaved surface. 10-605H makes it a public nuisance to park or store any vehicle on an unpaved surface. During his inspection, Senior Sierras Nunez observed a vehicle parked on the grass, which is an unpaved surface. That vehicle is depicted in this photo, which is in the appeal packet, page 30, parked on the grass. And finally, violation number 5 was that it appeared that there was stucco work being done without permits. Section 11-103, again, states that the FMC adopts the California Residential Code, and that is again reproduced there, but anyone who intends to alter, repair, change, etc., a building must be first required to make an application to the building official and obtain the required permit. And during the inspection, Senior Sierras Nunez observed the exterior of the building to be unfinished, and it did appear that it was being prepared for stucco. Again, some of the photos are, there's quite a few photos reproduced in the appeal packet. A couple examples are here. You can see that like kind of mottled gray color of the building, and in the second photo on the right, you can see that the columns below are a different color than the building above, and that the way the building appears does appear that it has been prepared for stucco in some phase of the stucco. Second factor would be that the proper notice was served on the property owner. On December 4th, the notice and order was posted on the exterior gate of the property and also mailed by both first class and certified mail. Proof of those actions is in the appeal packet, pages 19 and 20 and 26, 27. And the notice and order did contain all the necessary information required by the municipal code to be contained within a notice and order. Staff recommends that the Building Standard Appeals Board deny the appeal and confirm the notice and order issued on December 4th. Staff and the inspector are here for additional questions. Thank you.
If I may, a couple of questions of staff. Clarification, violations 1 and 5 seem to be almost duplicates. What's the differentiation between 1 and 5? Because stucco is part of doing unpermitted work. And so I'm trying to find out what that differentiation is.
For the stucco, that would be for the exterior, and then for all the plumbing fixtures, that would be for plumbing. That's
more like interior violations.
Yeah, interior violations.
Okay, because I'm just looking at, does it lump into one big thing of a total renovation without permits instead of 2 separate violations? I don't know if that makes a difference, but I'm just trying to get clarity on that.
I think one of the goals was to make sure that all the different aspects of the violation of the multiple violations that had been observed were clearly called out so that the property owner could respond to each of them and not, get a permit for one thing, but not realize that we'd also noticed something else that needed a permit.
Agreed. I'm just trying to make sure. Further, following up on this, the truck that was photographed parked on the grass looked like a construction truck. Mm-hmm. If they had permits, would you have violated that?
Yes.
Okay.
Yes.
Just trying to get clarity on it.
Yes, and just for the record as well, that was a violation that had been removed at the reinspection. So
okay.
We acknowledge that as of the reinspection, that violation did not exist. The vehicle parked on the grass.
Okay, that's what I have for right now.
Now I would like to ask that the presentation from the project applicant. Do we have that?
Good afternoon. My name is Michael Titus. I'm an attorney for the property owners here, Bryce Hovaneshian and Jennifer Hovaneshian. I have Bryce Hovaneshian here behind me as well for questions if anybody needs some later on after the presentation. I just want to note that to get started, Van Ness Boulevard is a street on which subject property is located that is not a stranger to constant renovations and cosmetic work done on many of the homes up and down that several-mile strip. Mr. and Mrs. Hovhannisyan are no different than any of those other homeowners along Van Ness and should be treated similarly as those homeowners. However, the appellates of this matter believe that the subject notice and order is, quite frankly, nothing more than a targeting of Mr. Hovhannisyan due to the city code enforcement department's distaste for him and his related companies. However, as to the notice and order itself, this arose from an exterior inspection which occurred on December 3rd of 2025, which alleged 5 violations that allegedly needed to be corrected. As to item 1 within the notice, it states that the house is being remodeled without the required plans, permits, or inspections. Again, I want this noted that this was an exterior inspection that was done behind a wrought iron fence, and the only thing visible for the code enforcement officer is what he and even the staff admitted it during their presentation of what he might have seen, what he thinks he might have been able to make out from behind the gate. And again, Mr. Hovhannisyan is here to answer a lot of the questions of maybe what be the scope of the work and maybe in some of those photographs that the city presented in their appeal packet. Now, I want to note that, as I said, I have the property owner here, and the work that is being performed is nothing more than tiling, putting in new tile, flooring, and painting. And the city has questioned this due to the visualization of a toilet and sinks in the front yard. However, replacing a toilet and replacing sinks, it does not require a permit if there's no structural alterations and no plumbing line movement, which has not occurred here. As to the large plumbing fixture, that is a drop-in tub. And again, the board is more than happy to speak with Mr. Hovhannisyan about this issue. That tub was simply removed from its original spot. The flooring was put in and then dropped back in where it was thereafter. There was essentially disconnected, then reconnected. There was no moving of plumbing lines or structural components. Now, as to the vehicle present, Mr. Hovhannisyan can provide substance to this, but this is from a company called Bill Lewis Painting, a company that is headquartered in Madera, California. Again, this is painting. It's not work that requires a permit. And as to the alleged unpermitted stucco, nothing within the building code prevents, I believe, a appellant or property on this case from conducting cosmetic work on existing stucco, which has been there for decades on the existing house. And again, this board is more than welcome to ask Mr. Hovhannisyan about the scope of that work. I do want to consolidate the 2 items, 2 and 3, in regards to the junk and rubbish and material. We submitted some photographs for the city, but again, for this presentation, as I mentioned, this property is located on Van Ness Boulevard, which is subject to cosmetic work being done day in and day out, year-round. If I could ask for those photographs to be up. Yeah, just Exhibit 1, please, and I'll just say Exhibit 1, 1A, 1B, yeah. So all the photographs I want to show are homes that are within the vicinity of the subject property. Again, this is a stone's throw away from the property on Van Ness Boulevard. If we look at it here, there's plenty of material and lumber left out in front of this home as well. If we go to the next photograph. Whoa. Same thing again, stone throw away. We have what looks like a potential seed train, but then if we see next to it, we have junk and rubbish next to it as well. Not to mention that this house has been going for renovations that Mr. Hovhannisyan can confirm for his neighbor that's been going for years on end for an extensive period of time. If we could go to the next photograph. We have more junk and rubbish as well. Looks like a boat being stored, which potentially could be a violation against the Fresno Municipal Code in the front yard of this property. If we could go to the next photograph, please. I think this is the last one that are all labeled for Exhibit D. Another home as well that's having renovations is done as well that has junk and rubbish as well in the front yard. And that kind of begs the question of if whether or not these other property owners that are located on Van Ness are going through these same inspections and procedures as well as the Hovhannisyan family. As to the materials itself, the city has provided no proof as to how long what was photographed in the note within the appeal packet as to how long these materials are out there. I mean, a toilet is removed. It could be there. It's not like we have photographs from August or October or July of 2025. This is a photograph from the initial inspection. These materials that, again, Mr. Hovhannisyan can confirm this, are moved in and out daily, right? Things are moving. It's not like they're sitting for years on end. As to item 4, the vehicle being parked on the unimproved surface dirt lot, I think the board here needs to look at the totality of the photographs that the city submitted with the appeal pack, and it'll show that just one tire, the back left tire of that vehicle, is parked on what looks like grass, or I'm sorry, not grass, but dirt, and even that dirt may have gone onto the driveway. So, and this is not a vehicle from the photograph. It's not dilapidated. It's not missing a license plate or a registration. It's something that's coming in and out daily. You know, I don't know the extent of what this worker did, but maybe he backed up too far and that one tire went on to that unimproved area. But as the city noted, they said that this has been corrected, yet they're asking this board to deny the appeal for the entirety of the notice. So as to the stucco, as I mentioned, this is pre-existing stucco. It's been there forever. It's not an alteration. It's not new stucco, or I'm sorry, it's not adding of stucco onto a property that didn't have stucco. And for these reasons, we believe that the appeal should be granted. I will say that Mr. Hovhannisyan did attempt to contact the code enforcement officer who conducted the inspection. He did not hear back from him for quite some time until December 24th of 2025. At that point in time, the appeal had been submitted, and we are here today. So with that, I'll allow questions for either myself or Mr. Hovhannisyan.
There aren't any questions at the present moment. Thank you.
Okay.
We do have a question from staff.
There, now it's on. So stucco new, the issue there is drainage, water going through. You need some water protection behind and terminating at the bottom of it. That sounds like it's all there. So if this is just a paint stucco coat, you would have no way of knowing that looking at it from the street. But if that is the characterization of what's going to happen, I don't think that requires a permit. Can you verify that, putting a color coat on a stucco house?
I would also like to, since we have the building official here, in case you have any comments as well, he would be a great resource.
I have one other item too while you're thinking about it. I've been told toilets do, and I'm a design engineer, only because of the wax seal. You don't get that wax seal on there, you got big problems. So I could see that needing a permit, but let's defer to the building official.
Could you pull up the picture of the stucco? Or Portland cement plaster, I don't know if you guys use stucco because it's copyrighted.
If you hand me the clicker, I can get through to the right photos as well. It's not here anymore. I'm like, I didn't grab it. Okay.
Yeah, from what I saw on the picture, and that's the reason why I'll wait till it shows up here, but it looked like there was chicken wire.
Right there.
And if there is chicken wire, then there would be attachments to backing, and there would also be, you know, some sort of it would be an oilless or bituminous paper behind it to block any type of moisture. And so that's what I would look at as calling out for inspection on stucco wire backing and also stapling.
Can you also comment on the toilet? That was the question.
Actually, if we go, yeah, if you want to go back to the large, it looked like it was some sort of a hot tub type, you know,
Right there.
destruction.
Oh, wait, one more back, sorry.
Yeah.
There we go.
Yeah, right there. So usually you have a, 220 type wiring that is attached to this tub, this hot tub. And so any type of modification to an existing wiring, existing house, you're going to need to have some sort of an residential electrical permit because it's a life safety issue, right? So with regards to the plumbing, the modification of the plumbing, if there was any moving of plumbing, either water, hot water, any effluent lines or anything like that, you're going to need to have some sort of a plumbing plan associated with a residential permit and electrical. And then if there's modifications to the exterior for removal of stucco and replacement, right? Absolutely, you're going to have a permit for that. If it's a dashing, a redashing, right, what you call like a color coat, okay, then that is just painting, right? But it looks like in this case that there's more than just a quote-unquote color coat.
And I did have a couple comments in rebuttal to the appellant's presentation. In this case, we did receive a complaint. Code enforcement received a complaint from a constituent regarding the work that was done. That is the reason why code enforcement was at the property. There is no retaliation or anything else that was claimed. And if any of those other properties that are in the area are in violation, we welcome complaints. I don't know the addresses of them, so I can't confirm whether there are any open cases. Additionally, as stated, yes, these are observations from the outside of the fence and an exterior inspection. That was the access that we were provided, and when the inspector did speak with the property owner, it was suggested that if these violations were at all inaccurate, that code enforcement would be willing to do an interior inspection to observe more closely the exterior of the property and also to see what the work was that was being done inside. And it's my understanding that that offer for an interior inspection was declined. Right now, we are asking for the notice and order to be confirmed. There have been no citations issued, no monetary citations issued as a result of this complaint. However, we are asking for each of these violations to be confirmed based on the evidence that was provided, and the again, it's a preponderance of the evidence standard as to whether or not those violations existed during the inspection. Additionally, there was a comment made about how much time the violations have gone on. I did want to present as appellant's exhibit, city's exhibit 2, or however we're going to mark it. There were some photos taken today. If the board is interested in seeing the current condition of the property, there are some violations that still remain. There's still some materials that are outside. So I can provide a copy to appellant. And then also provide additional to the board and other members. In these photos, you can see again some items that are still remaining on the exterior of the property, as well as something that has been done with the column that had previously been gray. Yeah, I think that is what these photos reflect. So, thank you.
Question for you, Eric. Just for now and for my future edification, replacing a toilet, does it require a permit? A toilet? Okay.
Remove and replace a toilet, you're correct. You don't need to have that. But if you relocate the toilet, right, relocate the effluent line
Yes.
and the water lines and so forth, that would require an alteration.
Good clarification, thank you.
Would you like me to repeat that? Okay.
Eric, I got a question about the hot tub. They said that they removed it just so they can do the tiling, and then they put it back in. So that's not really that they're remodeling the floor, and to be able to finish that, they had to remove the tub, and then they put it back in the same way that it was put in. Would that require the permit?
My quick answer to that is absolutely yes. And the reason why is how did you, for the removal of the 220, how did you remove it? How did you repair it? So it's extremely important to realize that any type of modification of any electrical, okay, we look at it as an alteration, right? And so that is it's very important that we make sure that the public knows that any modification to electrical requires permits for alterations.
Perfect, thank you.
Any other questions or concerns? Does the owner want to present?
If I could just comment on these photographs really quickly that we just got right now.
Well, can you step forward and talk?
Just really quickly, and then I know Mr. Hovanesian wants the opportunity to talk about the scope of the work to kind of comment on the tub issue and the stucco. But I mean, we can see from the photographs today that none of the material that is present in the front yard was in these prior photographs from 2 months ago. This is new material, and also we can see that the cars or work vehicles that are there as well are not the same. So again, we're talking about material that's constantly moving in and out, as well as vehicles that are constantly moving out. That, with that being said, I know Mr. Hovanesian wants to speak about the scope of the work, because there's a lot of comments on the electrical as well as the stucco. So,
Thank you. Mr. Hovanesian.
So as far as the tub is plugged in, it unplugs. There's no electrical modification that's done there. Same thing as changing a dryer. It plugs in and unplugs. There's no permit for requiring a dryer to be changed. There's no permit requiring for a toilet to be changed. There's no permit requiring for a sink to be changed, because all of the glued-in plumbing fixtures are not moving. The tub is a drop-in tub. It lifts out and drops back in. That's all that was done so that we can go from tile to a slab. The stucco work is all redashing. There's no chicken wire has been done on anything on that. The original weep screeds, everything is all original. We've gone over the top, because if you look at the pictures, you can see above the front door, see the stucco there, and it's really wavy. My wife didn't like it. We're going over the top of it. We haven't changed nothing. The entire house was stuccoed, has been stuccoed since the beginning. There was no siding on the property at all. Nothing has been changed. The only thing that has come out are a couple of decorative columns that had no support within them. They're precast, so it's a netting with kind of like it's almost like a fiberglass and then a plaster on top of it. Those have been removed. They're purely cosmetic. I had them inspected prior to them being brought out. They drilled holes, sent in a borescope. There was no beams within them, and they were removed. So a lot of the downspouts have come down. Some of those have been taken and recycled. There's new downspouts out there that just came down So everything that you're seeing there on the property is changing as quickly as I can get people to change it. I don't like that this has taken as long as it has, more than anybody else, but I have not done any work yet that requires a permit or plans. In fact, I've held off on doing any solar on the house because that's going to require permits and plans. So everything that I've done has been purely cosmetic.
I have a question regarding that, the hot tub. I don't think you can plug it in and plug it out. So in my opinion, understanding that is that there is electrical involved and there should be a permit pulled when you're dealing with 220. That is basically my opinion, of course. And I just want to see a model or a spec on what you're talking about.
It plugs in the same way that an electric dryer plugs in.
No.
It's a 220 volt outlet.
Sure, well, I will reserve my judgment until I see specifications on it.
Okay.
And anybody else?
Madam
Maybe
Chair.
one solution, because the difficulty in this whole thing right now is he said, she said type thing. Okay. Code enforcement saying they observe stuff on the outside. Would you be willing to allow them to go with you? They've got the original plans, I assume, available to them at City Hall. Do a walkthrough to show that all the things were just cosmetic, because that puts a lot of this at ease. If the toilets were simply removed to change out tile, got the plan, it matches, we're good. So would this be a possible solution to resolve this notice and order?
At this point, it's not. I don't think that they have a right to go into my home, and so I'm not willing to allow that.
Eric, I believe that the building code does give the right to entry. Am I wrong, or let me know?
Actually, yes and no. Yes, if the owner grants us the ability to go in, right? And two, if we require to go in and actually do an interior inspection, then we would get code involved. And usually there's a warrant, and there's usually a very specific process that code has for getting entry into private property. Chris?
Going back a minute, I appreciate your suggestion. That was also going to be my suggestion. We've been asking for an interior inspection in order to be able to verify that the complaint that was received is unfounded. And right now, we don't have the evidence to be able to say that it's not, because again, the observations that were made show that it may be. To Eric's point, yes, what code enforcement has the authority to do would be to get an inspection warrant through the court. It's not doesn't have the same standard as a search warrant, like a criminal search warrant. It is a civil inspection warrant, but that would be granted if the court is satisfied that there are evidence of on the exterior of the property that there may be violations on the interior. So that is an option that we could pursue in this case.
Madam Chair, one item for you. At one time, I had a spa in my backyard, and it did plug in, and it was 220. So they do make them. Unfortunately, there's a lot of solar people out there that don't get permits for these tubs and things, so it's probably, you find a few of them in Fresno.
I'm good with that. At this point, we need to discuss it and determine. Yes, we will close it to the public, and let's begin discussing it among ourselves. Is there anybody else that wants to say anything before? Okay, we're closing it to the public.
First time we've done this, do we retire or does the audience retire? It's closed to the public.
No, this isn't closed to the public. It's just the public hearing.
I heard closed to the public. Different.
It's the public hearing, so that
Agreed.
we get to talk among ourselves, but
They get to hear.
unless we specifically ask, no one else can step up.
If I could just clarify the process, the hearing has officially been closed by the chair, and now it's just simply time for board discussion and action.
Okay, thank you.
Speaking.
I believe there's a few of the violations that can just be marked off, like the truck parking on the grass because it's construction. And the stucco, if it is just redashing and repainting, that's a violation that could be removed, I believe. And the storage of the stuff outside, as we can see, it's different stuff as it's going. And so there's a few of them that can be taken out. Anybody else a thought on that?
I agree with you. It looks like standard rehab type of work. You've got to put that stuff somewhere. It could have been in a garage, but maybe something's going in there. Toilets, I think, are now that we don't need a permit. We're just taking a toilet off and putting it back after you finish with your floor coverings. It's not an issue. So it sounds like most of them could be alleviated.
Well, I agree with that. What I'm looking at is 1 and 5, which are about as any of this work requiring a permit. And at this point, we have the applicant's testimony that it doesn't, but we have no verification of that.
Right.
And my issue is refusing to grant inspection rights. I don't know what to do with that. And because I really don't know that I can make a finding on 1 and 5 without knowing the truth about what's going on here.
Refresh my memory, what were 1 and 5?
Those were work without permits.
Right.
And we're trying to establish whether it was simply taking things out to replace tile and putting it back in or not.
Okay.
1 and 5.
But there's
it's the hot
also.
tub
And the stucco.
and the stucco.
Stucco on hot tub.
And
Stucco
stucco,
plumbing.
yeah.
Yeah,
But
those
the
are-
other thing is, there was also notes of concrete being found, which sounds a little bit more than replacing tile.
Right.
And in all honesty, I used Google Maps before this. And on Google Maps, there was a pile of rubbish in front of the house on the street that appeared to include things like chunks of concrete. And it raises questions. The concrete's the big thing that worries me. Could it be just redashing? Okay, I can understand that on the stucco work. But not knowing what's going on inside, and my feeling is everybody on the block's doing it is not an excuse.
No, because one of those buildings, that was a brand-new building, that one obviously had to be permitted for the work that was being done.
Yeah,
And we can't say that for any of the other ones that are being remodeled, if their work has been permitted or not.
that's it. We don't know about those.
No complaint on those.
You know, it's no different than when you get pulled over for a speeding ticket and you say everybody else was going fast, the cop doesn't care.
Can I
So-
weigh in?
Sure.
So this is really simple and open and shut for me. I first want to thank the staff. I thought the staff did a beautiful job in their presentation. It's very clear, very concise, very informative. Having said that, I am, at this point, ready to rule in favor of the appellant. I think that we are not here to, how do I say, inspect the property. We're not police. We're not code enforcement. Our job is to judge based on the facts presented in front of us, and there is reasonable doubt, if you will, that the appellant is innocent of these charges. I think everything he said makes perfect sense. I grew up in the trades. I've been there. I've done tile jobs. You've got to remove stuff in order to put it in right. He obviously is not the boss at that place. His wife is the boss at that place, right? There's a wave in the wall. He's going to fix the wave in the wall. I say, congratulations on a good and long marriage. You and I think, are straying from what we're supposed to be doing by not looking at what's in front of us and judging based on that. So that's why I am ready to agree to, I don't even know what the word is, agree to the appeal. I'm having an open mind, but so far no one has swayed me from it.
I tend to agree with you because there's so many, in construction, there's so many variables that you can say, I didn't take a permit, I took a permit. It's all out there. And the only question that I have is that why aren't we allowed to let the inspector go in? That's my question.
Well, again, my position on that is very clear. It's not our job.
It's not our job.
We're not supposed to say, oh, we need further evidence. We have the evidence in front of us, and that's what we're supposed to judge on.
Yeah.
If, for example, if that was a true concern, well, then code enforcement should go back. They should start over again and say, we'd like to see inside your house.
Exactly.
And he
It's
has
not
the
us.
right to say no.
Yeah.
But here we are.
Let me understand what you just said. Are you in favor of upholding the city's position?
No.
Or plaintiff's? Plaintiff's position. Okay. Thank you.
Well, we should call in for some sort of, okay.
Excuse me, Board, I'd just like to make a comment because there was a reference to guilt beyond a reasonable doubt. The standard here is the preponderance of the evidence. So that means that if it's 49% and 51%, you rule in the 51%. If it's a tie, then it's a tie. But if it's more likely than not that a violation may have occurred, then the burden is met. So
Thank you.
Thank you. Well, should we have, let's have a motion and decide what you intended, that you would
Yeah.
like to.
I move to grant the appeal.
Do I have a second?
I second it.
All in favor?
Aye.
Aye.
Aye. Opposed?
Nay.
So it's 3-1, 3-2.
3-2.
All right. That's our decision.
Thank you all for coming in
Thank you.
today.
So we've done this one. Okay. So item number 9, we have a report from the secretary then?
Yes, report by secretary. I believe that we had meeting minutes from last, we do not. We will be adding those? Okay, excellent. Nothing further on report from the secretary.
Okay. How about unscheduled oral communication? Any unscheduled ones? It doesn't say here.
board or from the public?
I don't see anybody here. Okay, so on that, oh, there is one.
Just to clarify, unscheduled oral communications is an opportunity for the public to comment on anything that is not on the agenda.
Ah, okay, thank you so much. So shall we adjourn for today? It's adjourned. And it's 2:20. Thank you.
Any of those matters amongst
I think that is a question for our city attorney's office, but I would say that's not decided.
The question was asked, can they continue the discussion of the decision that was made by the board?
I believe that you've already made a decision, so that's already etched in stone, not etched in stone, but it's actually formalized. So now you're just having an informal discussion among you. You're not going to make a decision of anything in the future. You're just casually discussing what occurred today. I would suggest, yeah, off record.